Hi students, I am Professor Kshitij Bansal and I teach International Law at Jindal Global Law School of OP Jindal Global University. The module which we are going to discuss today is about non-state actors and international humanitarian law, implementation, violation and its accountability. What would be the learning outcomes after listening to this briefing? This module will bring forth the implementation mechanism that facilitates its execution qua the non-state actors. The students will also learn about the conceptual foundations through which the applicability of international humanitarian law can be enforced on the non-state actors. Let us now begin with the introductory part. This module continues the parallel exploration of the frameworks of international humanitarian law, which we would be referring to as IHL for our conveniences, and international human rights law. We would refer to it as IHRL or HRL. Both of them share the basic similarity of their aim being the protection of persons, but which also have different specific purposes and contexts attached to each of them. This module will bring key provisions and doctrines of both systems of law as applicable to non-state actors. Over and above this, the module will touch upon the methods of implementation of IHL. It will urge the reader to appreciate the binding force that IHL is intended to have. However, it will also attempt to critically acquaint the reader with the role of legitimized force in upholding principles of IHL. The module will achieve this end by educating the reader in strategies from humanitarian engagement with armed opposition groups. The module will first set out important treaty-based provisions and customary law principles that are applicable to state and non-state parties equally. The module will also bring out the important theories of when international humanitarian law would be applicable, including the de facto control theory, situations when customary international law applies, the grave breach theory, and the legislative principle. The module will then attempt to ground the difference made by IHL between combatants and civilians. Once this distinction is clear, the essential concept of what is in furtherance of a military object will also be clarified to the reader by this module. In particular, this module will clarify what the Martens Clause is. The module will also introduce the Martens Clause as a principle of customary international law. Finally, the module will also bring out the intersection of international organizations such as the United Nations and the International Committee of Red Cross in the implementation of international humanitarian law. It will move on to highlight how the United Nations has got more proactive in its approach to preserve the global order of international humanitarian law. What is the overarching aim of the section? It is to give a brief overview to all of you about the content of human rights law and humanitarian law and the method of their implementation between their interactions. The module will also aim to give a bird's eye view of the possible route of evolution for the subject matter of international humanitarian law. To begin with, we would talk about the applicability of IHL and HRL to non-state actors. At the outset, to understand this module, it is important to be able to identify the distinction between state actors and the non-state actors and the rationale behind the applicability of IHL norms and HRL norms. It is worth reviewing here the definitions of civilians and the principle of distinction between combatants and civilians. The definitions are taken from the ICRC's study on customary international humanitarian law, which we will discuss in more detail later. The definition goes as follows. Civilians are persons who are not the members of armed forces. The civilian population comprises of all persons who are civilians. Civilians are protected against attacks unless and for such time as they take direct part in hostilities. Military objectives are limited to those objects which by their nature, location, purpose or use make an effective contribution to military action and whose partial or total destruction, capture or neutralization in the circumstances that the context refers to, ruling at that particular time, offer a definite military advantage. Civilian objects are all objects that are not military objectives. Civilian objects are protected against such attacks unless and for such time as they are military objectives. As a reminder, human rights law is directed primarily at states, albeit for the protection of individuals, while the applicability of IHL to states is of a different kind. IHL provides protection from not states but those involved as participants in the armed conflicts or non-state actors. These include combatants or parties to a conflict rather than only high contracting parties to the treaties, which are understood to be the states. In both the bodies of law, according to more general principles of attribution, the acts of individuals may be attributable to states. Other definitions are relevant, and they are as follows. State actors or high contracting parties. State actors or high contracting parties to the Geneva Conventions refer to states that have signed and ratified the Geneva Conventions. It means that the states agree to be bound and governed by the Geneva Conventions during an armed conflict of an internal or international character happening within their respective territories. Non-state actors is the second definition. Non-state actors refer to armed rebel groups, civilian combatants or peacekeeping forces within the territory of the high contracting party. Generally, while characterizing a group as a non-state actor, it is important to show the absence of or the involvement of the state or the high contracting party in the command, control or operation of the group. Essentially speaking, that there has to be some sort of a state support. Applicability of IHL to non-state armed groups remains somewhat elusive. Different explanations of why such groups are bound by those conventions, in spite of their having not signed up to any of them, have been offered, none of them being fully satisfactory. Possible justifications for the binding effect of IHL on armed forces and armed non-state actors are as follows. First, legislative principle. Non-state actors are bound by IHL by the reason of their being active on the territory of a contracting party, a state party to the Geneva Conventions and or its additional protocols. This theory is also referred to as the principle of legislative jurisdiction, pursuant to which the agreements which a state enters into are automatically binding on all non-state actors within its jurisdiction. What is the limitation of this theory? The limitation is that this theory fails because it uses as its basis the representative character of state decisions and the presumption of consent by all of its subjects. In reality, there are no groups that feel less represented by the state than armed opposition groups. The theory binds those groups by international humanitarian law without their consent. The second rationale giving this explanation is the grave breaches theory. In the field of international criminal law, criminal responsibility attaches irrespective of the capacity. There is no denying that some more serious violations of international humanitarian law qualify as grave breaches or international crimes to which international criminal responsibility attaches. It also has a limitation. This responsibility is individual and not collective in this theory. There are no indications that entities such as armed opposition groups incur qua entities, that is separate from their constituent members, international criminal responsibility for the violations of international humanitarian law. Article 25 of the ICC statute referring to natural persons, Article 6 of the Charter of the International Military Tribunal, the Nuremberg Charter, which refers to individuals and members of organizations. Third is the de facto control theory. It can be argued that because some armed groups exercise de facto control over territory, they behave like states. International obligations usually are binding on states and should also be incurred by those armed groups. The limitation is, even if this is accepted for some armed groups who meet this criteria, as not all of them exercise territorial control, it is not a general theory. The final way of explaining this is through customary international law. The final way to circumvent the consent problem is drawing upon a classical international law approach. Whereas in international law, treaties are based primarily on consent of the parties for their binding force, the other major source of international law, customary international law, is not about consent, but an accumulation of practice which demonstrates the acceptance of a binding effect on the community as a whole. There's also a limitation. In the end, though even custom is only attenuated demonstration of consent, at least by the parties who have demonstrated a practice, willingness to comply on the part of an actor is crucially dependent on the perception of its having consented to, or at least of having participated in the formation of the law one is bound by. Also, they have to be accepted as the kinds of actors who can create the kind of practice other international actors, including states, would agree to be bound by. Customary international humanitarian law, let's talk about this now. In circumstances where the high contracting parties are not signatories to the Geneva Conventions, minimum customary international law is applicable. Customary international law is applicable because it is a universal law and it must be followed at all times. The foundation of humanitarian law principles through custom is contained in the Martens Clause, named after the Russian delegate to the 1899 Hague Peace Conference. The clause, which we are calling as the Martens Clause, states as follows: in the cases not covered by this or other international agreements, civilians and combatants remain under the protection and the authority of principles of established international law derived from established custom, from the principles of humanitarian law, and from the dictates of public conscience. The next logical question is then, what principles of humanitarian law would constitute customary international law? Jean-Marie Hencatz enumerates the customary rules of implementation or ensuring compliance with international humanitarian law. Rules 139 to 149 cover implementation as well as state responsibility. IAC indicates applicability in international armed conflicts. NIAC indicates applicability to non-international armed conflicts, wherein typically at least one party is an armed non-state actor. Rule 139 says as follows: each party to the conflict must respect and ensure respect for international humanitarian law by its armed forces and other persons or groups acting in fact on its instructions or under its direction or control. This is IAC or NIAC. Rule 140: the obligation to respect and ensure respect for international humanitarian law does not depend on reciprocity. This again would be IAC or non-international armed conflict, that is NIAC. Rule 141 says each state must make legal advisors available when necessary to advise military commanders at the appropriate level on the application of international humanitarian law. Talking about Rule 142, it says the states and parties to the conflict must provide instructions in international humanitarian law to their armed forces. Rule 143 states that the states must encourage the teaching of international humanitarian law to its civilian population. Enforcement of international humanitarian law will be another question that you may want to ask. Rule 144 begins to answer that. States may not encourage violations of international humanitarian law by parties to an armed conflict. They must exert their influence to the degree possible to stop violations of international humanitarian law. Rule 145 goes on to say, where not prohibited by international law, belligerent reprisals are subject to stringent conditions. This essentially would be international armed conflict, not non-international armed conflict. Rule 146 says that the belligerent reprisals against persons protected by the Geneva Conventions are prohibited. Rule 147 takes us further by saying that the reprisals against objects protected under Geneva Conventions and Hague Convention for the protection of cultural property are prohibited. This would qualify as international armed conflict rule. Rule 148 goes further and says parties to non-international armed conflicts do not have the right to resort to belligerent reprisals. Other countermeasures against persons who do not or who have ceased to take a direct part in hostilities are prohibited. Rule 149 says a state is responsible for violations of international humanitarian law attributable to it, including violations committed by its organs, including armed forces, violations committed by persons or entities it empowered to exercise elements of governmental authority. Third is violations committed by persons or groups acting in fact on its instructions or under its direction or control or influence. And fourth, violations committed by private persons or groups which it acknowledges and adopts as its own conduct. This would qualify as IAC or non-international armed conflict, that is NIAC. The next topic we can talk about is the application of human rights law to the armed conflicts involving state actors, and I would begin by saying that this aspect faces very similar challenges in the application of IHL norms to non-state actors. The human rights law. The human rights law comes into picture with the beginning of this discussion. International human rights law is applicable at all times, including in the armed conflict. This has been formally confined on several occasions by the International Court of Justice, Thus, in contrast to international humanitarian law, there is no need to assess whether a certain threshold of violence has been reached, although certain aspects in certain situations a party to whom derogatory behavior is being attributed to, it may be allowed to derogate from full observance of specific rights. When the threshold for the application of IHL has been reached, both bodies of law will generally apply in a complementary way. The applicability of human rights law to armed non-state actors is, however, controversial. One of the reasons put forward by scholars refuting the applicability of this body of law is that the rationale of human rights is the regulation of states and not private actors' behavior with respect to individuals under their jurisdiction or control. Admittedly, in contrast with IHR instruments, few human rights treaties explicitly seek to bind armed non-state actors, although the situation is evolving. A narrow conception of human rights law does not, however, correspond to the basic philosophy of human rights or to reality of many situations in which armed non-state actors operate, as suggested by a leading scholar, Professor Andrew Clapham. The most promising theoretical basis for human rights obligations for non-state actors is first to remind ourselves the foundational basis of human rights is best explained as rights which belong to the individual in recognition of each person's dignity. The implication is that these natural rights should be respected by everyone and every entity and must not have any qualification behind them. From a technical point of view, there seems to be a broad agreement among experts, lawyers, and academics that international human rights law could be applicable to armed non-state actors in specific circumstances, in particular when they exercise elements of governmental functions and have a de facto authority over a population. This will normally be the case when an armed group controls a certain portion of the territory. Indeed, the need to regulate the relationship between those who are governed, which characterizes the raison d'etre of human rights law, would be reproduced and thus would justify the application of that body of law. We have seen international bodies active in the implementation and enforcement of IHL, as well as human rights law courts and tribunals taking up non-international armed conflicts and internal strife. Competing claims of comprehensive legal framework can also impede their acceptance, in part due to the actual gaps and overlaps in their coverage. For example, thus far, no unified body or treaty of customary international law has set forth a comprehensive framework for non-belligerent occupations and peace-building missions. You should think about the situation in African countries, for example. Strategies to gain the adherence of various groups to basic humanitarian standards must include a series of practical steps for all parties to ensure compliance with these standards. Such institutional options may take many forms, including unilateral declarations, negotiated solutions, and top-down directives, and all of these forms have been used to implement international humanitarian law in otherwise difficult situations. Some of these have been successful even where de jure applicability is less certain or not accepted by all parties. Strategies from humanitarian engagement with armed opposition groups. While the goal of implementation is to bind parties to international standards, a strategic question that follows is whether to build capacity or build pressure in engaging with various non-state actors. For the ICRC and traditional humanitarian actors, neutrality cannot be abandoned or qualified, but there is a continuum of coercion available to these groups. Certain methods have developed for promoting implementation of IHL by armed opposition groups. These strategies can be generalized somewhat to reach and enforce special agreements bringing into force the provisions from international humanitarian law of international armed conflicts. Their effectiveness can be seen in the inclusion of armed conflicts in humanitarian initiatives, including the Geneva Call supporting the Ottawa Treaty banning anti-personnel landmines. According to Claude Bruderlin, implementation may involve either engaging in a dialogue with these groups and assisting them in building their capacity to respect humanitarian and human rights norms, or aiming at building pressure on these groups by shaming them in front of international public and their own constituency for the violations of international standards. The separation of these strategies brings to light two obstacles to implementation: incapacity and unwillingness. Both have to be assessed. Therefore, a careful analysis of the most promising path should be made at the outset. Again, without certain mechanisms to follow up and monitoring a group's commitments, most of the provisions of humanitarian agreements cannot be effective, and the provisions will remain mere parchment barriers. In the interim, as with ceasefires and disarmament agreements, the adoption of IHL standards as confidence building measures may also help facilitate communication, develop trust between parties to a conflict, and help repress violations. UN practice and other institutional precedents. Let's talk about this now. It is useful to look at the development of one of the key instruments extending respect and ensuring respect in a judicial gap. The Secretary General's memorandum extending the application of international human rights and humanitarian law to peacekeeping operations, Secretary General's Bulletin Observance by United Nations Forces of International Humanitarian Law. Remaining doubts about the applicability of international humanitarian law to the United Nations have been removed by the issuance of an administrative order by the Secretary General. Historians and legal advisors alike have had the opportunity to review the historical debate between the ICRC and United Nations, on the other hand, over the question of the application of IHL to peacekeeping operations. These authorities seem to be agreeing that there has been an evolution in the UN's position is agreed upon, but how one might characterize its accession to IHL is less certain. Since the 1950s, the applicability of IHL to UN forces has been doubted, and even international lawyers suggested the UN should simply select such of the laws of war as may seem to fit its purpose. As far back as the Korean conflict, the UN has argued that since it is composed of individual troop contributing states, the organization cannot take responsibility for applying IHL to their peacekeeping forces in peace operations. It remains uncertain that this instrumentalism has been transcended. Separately, it is argued that the organization as a whole must be seen to act on behalf of the international community and cannot be considered a party or power within the meaning of Geneva Conventions. The application of Common Article 1 would be thwarted if neither the United Nations as a non-state nor a troop contributing state, if its troops are under the UN command and control, would be held responsible for violations of IHL. States involved in UN authorized enforcement actions nevertheless remain bound by their individual obligations under the UN Charter, and this is particularly clear in actions authorized by the United Nations Security Council. The scope of these legal obligations is less clear if the Council deployed forces made available to it under Article 43 agreements. Finally, it has argued that UN peacekeeping forces must be reviewed as impartial, objective and neutral, perhaps in the sense analogous to the ICRC, and cannot be subject to IHL in the conduct of their operations. Over the same period of time, the ICRC took the opposite view of the applicability of IHL to UN forces in peace operations, though sometimes recognizing the same formal difficulties of applying Geneva Conventions. Over the past 2 decades, several developments sidelined the legal debate over de jure provisions while promoting the governance and the convergence of a pragmatic view. According to Daphna Shraga, Principal Legal Officer at the Office of Legal Affairs of the United Nations, first, in the 1990s, the UN began including a standard provision incorporated in status of forced agreements concluded between the UN and the host countries, stating that the UN undertakes to ensure that the operations of the force will be conducted with full respect for the principles and the spirit of the General Conventions applicable to military personnel, studiously avoiding recognized terms in IHL but naming, at the least, the Geneva Convention and additional protocols as examples. This amounts to a complex mirroring exercise where the UN translates IHL into its internal requirements, insists TCS in their agreements that these should reflect these obligations, therefore reinforcing the state's obligations to the general international humanitarian law. The UN, reflecting accurately the principles and spirit required of troops, remain a mirror, an illusory instrument avoiding questions of de jure application of the UN itself. It also avoids the issue of heterogeneity among TCS in their international obligations under the various treaties and provisions of the UN Charter. Thus, even at the principles and spirit phase, the legal position did not waver from the 1946 Convention on Privileges and Immunities of the United Nations and the 1964 Convention on the Safety and Security of United Nations and associated personnel, where these conventions allegedly cast the UN as immune to liability as the embodiment of the international community as the whole and characterized peacekeepers primarily as neutral and impartial observers to conflicts. Though the course of their duties, they might find themselves as custodians of vaguely military standards when engaging in self-protection and detaining persons or protecting civilians. It would be fine to conclude by saying that the section which we discussed just now has been able to highlight using broad strokes the contemporary debates and the issues surrounding IHL and HRL. IHL has traditionally distinguished between civilian and combatant population and has attempted to protect the former during the times of war unless they are a part of the hostilities. Its aim is really to make war just, while the HRL movement has traditionally been justified by arguing that its efficacy lies in protecting the citizen from a violation of their dignity and therefore operates against the state. In both the cases, the questions of law apply to non-state actors? That has been posed consistently by scholars. There is a case for both IHL and HRL to apply to non-state actors, since their theoretical scope is wide enough to envisage such a scenario of an expanded mandate. Furthermore, it is also conceivable that both IHL and HRL can apply simultaneously, as advocated by the convergence thesis. Therefore, it is important for us to ask how these systems of public international law and the international global governance are implicated in each other's success. Finally, I hope this module has given all of us a very basic introduction into the concept of implementing international human rights and humanitarian law in the middle of their interactions. If treaties and international law can't be implemented because of the lack of efficiency or efficacy needed to make the real change, however, with HRL and IHL, a system of governance which is designed to help with implementation. We must appreciate how the UN and other related bodies are all implicated in this system of governance, and they take part in it effectively and efficaciously. The overarching question that this module poses, rather ominously, it must be added, is this system of governance enough? While you develop your thought on this last question posed in the conclusion, we would conclude this discussion. Thank you for listening.